Now I turn to Gönenç for his 2 cents on this same question: merger policy, should we adjust or not?
Thank you very much. So this also goes into the question of what we're going to call a zombie and what we're not going to call a zombie. And there could be a lot of scenarios that would be very interesting. So past loss of a company leading to debt interests that are exceeding its profits, but that company being cash positive. Should we treat this as a zombie? Yes. Does that mean we should relax our merger control regardless of the circumstances? No. Does that mean, though, that we should be blind to the fact that this is a zombie during the merger control? Again, a no. So how do we not be blind to the zombie situation while at the same time not giving a carte blanche to these kind of situations? Well, we could be more candid with the efficiency defenses. We could look into the failing company defenses more carefully. And easier derogations are a perfect tool, so long as those easier derogations will not mean that they instruct the substantive test afterwards. So if we're going to comfort ourselves that this company being zombie is not providing enough opportunity for an efficiency increase after the transaction, and this is basically, say, for example, a leader-follower duopoly of an insolvent follower falling into a monopoly, and I just won't be able to allow this, right? Of course, there will be arguments of saying, well, you know what? There is going to be a higher capacity monopolist after the transaction. If you don't allow it, then it's going to be a narrower capacity monopolist. So it's a monopolist anyway. Why don't you allow it? But we will choose to believe, depending on what the barriers to entry are and very many things the competition authorities are going to look into, that a new entrant can find it easier to enter the market if we allow the zombie to die, instead of it being consumed by the incumbent in the leader-follower duopoly. So I'm not going to exhaust or try to exhaust all scenarios. All I'm trying to say is there will be so many case-by-case cases that the rule of thumb probably is going to be being a bit more lenient on the derogations, knowing that the COVID-19 circumstances and the circumstances of the world are going to increase the number of these occurrences, and easier derogations may allow for the zombies to be kept afloat and the transaction appetizing for the efficient firms. And then the competition authorities would sit on the steering wheel. And when they sit on the steering wheel, no carte blanche should be given because this is a zombie firm ultimately, because there could be very many cases where consumer welfare could be better served by not allowing the zombie to exit in the way that they're exiting. And the markets will also change our definition of zombies as well. So we won't be able to come up with a bright line rule about who's a zombie, who's not. A mine owner company could demonstrate that the mine owner company is finding it difficult to pay its past losses, debt interests, and its profits are exceeded by the debt interests. So technically this is zombie. But when we look at it, we would see that their reserves are making it a very valuable company. In which case, if another mine owner in the vicinity were to come and say, let me consume this zombie, they don't know how to run this mine, I know how to do it perfectly well, we're probably going to say that, well, you know what, the existence of that mine in and of itself is a ticket for entry into this market. So we're not concerned that we're going to see the labor and capital severed from each other. So this is not like computers suddenly floating to another market and the labor floating to yet another and us losing the zombie as well, and there is one less player to play. This is a mine. So I am comfortable that someone at some point is going to take this up. I'm just not going to allow you to take it. So there will be a lot of policy decisions that we will have to come up with. And no easy label is going to allow us to solve this issue. This is more a fiscal and monetary policy question, in my view, than a competition law question. which companies we should inject money with and have them afloat. The question, when it boils down to, can we overcome sincere merger control worries just because one of the parties is a zombie? The answer is going to be no. Just the mere fact that one company is a zombie won't in and of itself mean that we can overcome genuine merger control worries that are applicable post-transaction. But should we change our attitude toward those kinds of files? Yes, we should be quicker. We should give easier derogations. We should look into the possibility of unzombification, because we could be serving a cleansing recession if we do this. There will be a recession in some markets, we know this, but a cleansing recession is a controlled environment, and competition authorities and merger control can serve this interest. A dissolution may be inevitable, but it could be an orderly dissolution, or it could be a disorderly dissolution. And an orderly dissolution can be served by competition authorities making right choices. It just cannot come in the form of easy labels.
Gönenç, thanks a lot for that. That was very thoughtful. And I take, but correct me if I'm wrong, I take what you said as, let's be open-minded, let's be open-minded, and let's subject transactions to careful scrutiny. So, not say we do nothing or we give carte blanche. Let's open up our procedures to looking into these issues and carefully consider cases as they come. Maybe the broader thing that came to mind when you were talking is, in Europe, when the steel and coal community was created, there was a carte blanche to mergers, precisely for reasons of important industry restructuring. Industry was inefficient in steel and coal, and there was a big need for concentration and markets to allow this restructuring to take place. Then a few years later, people like Jean-Jacques Savant-Schreiber, we're in Paris, so we can talk about a Frenchman, talked in a book called Le Défi Américain about the management gap of European companies, and fully managed, very little innovative, and takeover between European firms was deemed by Jean-Jacques Savant-Schreiber a way to solve this problem of lazy, inefficient, and frankly quite uninteresting corporate structure in Europe. And in the merger reg, even there's a passage in the preamble which talks to the need, the fact that mergers provide opportunities for efficient restructuring of the industry. So I wonder whether the sort of megaphone of killer acquisitions and let's stifle merger control might not have make us lose the big picture about the sort of important restructuring force that mergers allow in a market economy. It's a market force, and it's good. It's probably better than having governments intervene by injecting subsidies and keeping the zombies alive. Jorge, I think you want to say something.
So I actually wanted to disagree to some extent with some of the things that have been said. So let me try to disagree for the sake of being also a little bit polemical. So first thing, I don't think that zombies is an empty label. Zombie firms, it's of course we can disagree at the margin on how we identify them, but I think that is a notion that is well established in the economics literature and that central banks use consistently. It has to do with internet debt coverage ratios, but also has to do with lack of investment, and it has to do with low profitability. So we can debate at the margin, but I think that broadly speaking, we can distinguish one from the other. Second, I don't think that zombie firms are a problem just for the fiscal authorities and the monetary authorities. In fact, the central banks are looking to us to help them with the zombie firms. I think that that's what you read from the European Central Bank, from the Bank of England, from the Bank of Spain, from the Bank of France, etc. They want us to help them because these companies are there. They are, in the European economy around post-crisis, around 10% of the European economy, and they drag a considerable amount of resources and represent a very significant, hurdle for the recovery. And we need to get them out of the market. And how do we get them out of the market? Merger control is an exit process. You're not going to get them out of the market because you're not giving them a stay date. Maybe the banks are going to keep them alive. You need to get them out of the market in different ways. And which ways? It's not obvious. You may facilitate bankruptcy laws so that they can take that route without the costs. You may help banks perhaps to restructure those loans and help the banks to kill the zombies. That's another possibility. Then there is merger control, which is an exit route. Are you going to deal with these mergers through the failing firm defense? No, it's impossible. The failing firm defense is not meant to deal with zombies, because zombies are not failing firms that are about to exit the market. They are firms that stay in the market no matter what, that you don't kill them. So how do you deal with that? Well, I think that what you need to do is a proper counterfactual analysis. Now, if all that you care as a competition agency is prices in the short term, you're gonna block every single transaction that involves a zombie firm, because these zombie firms, in a sense, are gonna look to you as a maverick firm, which prices very low. If you just care about short-term prices, then that's what you're gonna do. You're gonna block mergers, and you're gonna fool yourself, telling yourself what a number of economists tell all the time to the competition agencies these days, which is that recessions are temporary, merger control is permanent. Well, zombie firms are not temporary. They're permanent. They have been there for ages and ages. And look at Alitalia, for God's sake. They refuse to die. And so you're not going to deal with them unless you are prepared to think in a more complex counterfactual. What is the more complex counterfactual? These companies price low, and they force other companies, the healthy companies, to price low. Yeah, congratulations, consumers, you are doing fantastic in the short term. But then there is no investment. Then we complain about investment. Then, in our economies, there is not enough investment. Then the productivity growth in Europe is miserable. Then there is no employment. Oh, but we have very low prices, unsustainably low prices. Then there is, in a context of a merger review, an internal document from the merging parties that talks about. First thing that comes to mind, collusion. It doesn't come to mind, what these guys mean is that they need to kick out this zombie firm that is kept alive, but these very inefficient banks, and is ruining the market. Look, the truth may be one or the other, and it is for the competition agencies to disentangle what is the truth. But they can only do that if they are open-minded and if they look at a proper counterfactual. The counterfactual is not going to be exit. The counterfactual is, are we better off with an airline, with a company, a telecom company, unable to invest, selling below long run average incremental cost, even if average variable cost, and ruining investment in this industry with low productivity and low employment? Or are we better off with one less company, precisely this company, this, a disgrace of a company? If we kill it and we let that market to sustain somewhat higher prices in the short term at the expense of more investment, more productivity, greater growth, and lower prices in the future? That's the question.
So, Jorge, I don't know if you, we're going to see in a minute if you've been successful at being polemical, but I see two hands raised from Isabelle and Gönenç, so I'll give them the floor immediately. Isabelle.
Yes, I hope I'm open-minded, but I am not convinced so far by Jorge's call. I think that one of the key reasons why we are not today considering this and considering it a major problem for us is our mandate, which is to protect competition. And by doing that, we are not, of course, focusing only about price. I think that it's quite clear that the more difficult cases today in front of the agencies are not about price. We can have cases about that, but it's more about the effect of a merger on the global market and the all type of losses for the consumer deriving from the market. And of course, if a zombie firm is acquired by another, and then they are not dominant, they have 30% of the market, then what is the problem? So the cases in which this should be a criteria are by definition those in which the merger would be bad for competition. Otherwise, we don't have to discuss and the merger goes through. And we see quite a number of that type of case in which a company was not really very efficient and in the end is being merged or bought by another. And I think that if a company, Jorge has given us some example, survives without being efficient, this is much more a problem for the financial system than for us, because our mandate is not to get those companies out of the economy, it's to make sure that the market continues to work efficiently. So I hear, and of course, this is something that we will be able to discuss within the agencies and with other stakeholders, but I think that we ask a lot of agencies today, they should take into account a lot of different issues, environment, public interest, you name it. But I don't see this subject at the top of the agenda, and I'm sorry to say that to Jorge.
But Isabelle, if I may chip in, I know that Gönenç want to come in. I think that I may have explained myself badly because I was advocating in favor of consumer welfare. I'm not interested about the implications for the macroeconomy. That may be why the central banks want you to kill them. But I'm not, I don't care about that. The question that I'm saying is, you are not going to be able to deal with these mergers with a failing firm defense. You need to look at consumer welfare in the long run. Consumer welfare in the long run may be improved if you get rid of this company. Why? Well, prices in the short term will go up because that company is setting prices that are unsustainably low. But in the medium term, in the long term, you're going to have a more healthy market, and you're going to have more investment, and then you're going to have prices over quality, controlling for quality that is much higher. That may happen or may not happen. That's the issue that needs to be investigated. So all that, when I'm saying open-minded, is not about sustainability. I'm not particularly fond of those arguments. I'm not thinking about public interest. I'm not thinking about anything else other than pure consumer welfare, but not tomorrow. You know, looking with a time horizon of 2 years and think whether the permanence of that company in the market buys you very low prices today at the expense of less quality and higher prices in the future. So I don't think that I'm heterodox. I'm telling you, do a proper counterfactual analysis.
So Jorge, I mean, to sort of find some, to bridge, you know, what you both said, the European Commission in the Dow-DuPont merger took a long-term perspective on consumer harms, including in the process, not only prices, but also R&D, innovation, and so on. So there's, you know, between the political economy and macroeconomic issues and short-term market prices, there's a whole range of considerations that are competition policy considerations, which are relevant in the longer term range. And if anything, though DuPont was not particularly permissive in terms of its approach to merger control. So I think that's where the debate is.
And I agree. And I think that the Commission did the right thing by looking forward into investment. In that particular scenario led to more intervention. I believe that if you take that approach with zombie firms, you would lead to, you know, different, less intervention, perhaps.
Now we go to Gönenç.
Thank you. So actually, I do not disagree, I think, with Jorge. I just need a few calibrations. And I didn't intend to, but let me start with the Dow-DuPont matter and say the following as my observation. It seems to me that whenever agencies are going to articulate a problem, whenever they're going to even engage in scaremongering, they are able to look at things in a counterfactual fashion. They are able to look at things as a process or, you know, not as a snapshot. But whenever competition agencies are going to use it as a means of being more lenient or recognizing certain efficiency defenses and what have you, the way Jorge hopes is going to happen, suddenly the same attitude is not observed. So let me start with that duality. So I would agree that the Dow-DuPont kind of approach, if we had an efficiency defense version of that in our worlds, that would have been wonderful for the zombie firms on zombification, but we do not have it. And the fact that we have Dow-DuPont also doesn't mean that we're candidates for it, because when they're going to be restrictive and rejecting a prospective transaction, then you get that kind of an attitude more easily. And yet the flip side of the coin is not correct in my observation. It just doesn't happen with the authorities so easily. So going back on what Jorge has said, I didn't mean to use the term zombie as an easy label. It is an economical term, and it's very fluid, as I tried to explain, but it does exist. What is an easy label is relaxing merger control just because there is a zombie in the mix of the transaction. That's the easy label. And what is the antidote of that easy label? It is doing a deeper analysis and getting the time for that deeper analysis. Therefore, you need the derogation to be more easily flowing. And then you will be looking more candidly into efficiency defenses. That is why I actually employed efficiency defenses more than the failing company defense, because the failing company defense is going to be too static, too rigid for the purposes of unzombification, the orderly dissolution, the cleansing recession. So we will need to rely more on efficiency defense matters. And competition authorities hasn't been putting sincere attention to efficiency defense. There's quite a lot of lip service going into it, but a lot of competition agencies do not actually do away with their worries because there is a credible efficiency defense. And combined with the easier derogations and a more serious look into the efficiency defense, there will have to be a midterm process analysis rather than an existing snapshot type of a static analysis, and definitely a counterfactual analysis. This will, though, and this should, never mean that the authority is allowing for certain transactions that they would not have allowed had one of the parties not been a zombie. But it should mean that the authority is recognizing the zombie status of one of the parties, and the fact that in the form of efficiency defense, something that is introduced to them is possible only because one of the parties is a zombie. So on this occasion, you should allow us because here is what's going to happen in the market if you allow us. Here is what's going to happen if you don't, kind of a counterfactual analysis. This, the authorities are not listening to, in my view, at the moment when you go with the quintessential old school efficiency defense analysis, and they should be with an open mind toward the efficiency defense in at least those transactions where the zombies are involved.
Okay, thanks. That was very helpful too. So I'm just looking at the time. We are slipping a little bit, but I like the fact that we are generating spontaneous reactions on the panel. I see Karl rose his hand. Isabelle, you still want to add something, maybe? Maybe Karl and Isabelle. Karl.
Well, if I may, I don't want to react to the allegation that we are only looking at short-term price effects, because I think this would lead us to a different discussion. But I fear a bit that we are overloading the competition boat if, as Jorge said, fiscal monetary authorities are looking at us to solve the zombification problem. Because I think what we see and what we can deal with are only the effects, but not the cause of the problem. Because if there is a consensus that there is a significant number of zombie firms out there and that they are operating, they do so because they still comply with the regulatory environment, apparently. So how can it be that there's a consensus that these firms should not exist, but still the regulatory environment is not adequately dealing with this? So either the regulatory environment is not adequate, or there's no consensus about the fact that these companies should not exist. But if the regulatory environment is not up to the needs, then probably one should more look at this and look for solutions there rather than charging competition enforcement with solving the problem. And I think Jorge was very rightfully pointing to the link with the banking sector. So I think there is a clear link with the banking sector not adequately being restructured, and therefore banks not being capable or banks being charged with non-performing loans and a big non-performing loan book, and therefore not able to stop giving loans to certain companies. And probably there's also something which might not fully work with our insolvency system if these kind of companies can survive while they should not. So I think if we focus on competition law, I think we are not looking at the right instrument to solve the zombification problem.
Yes, if I may add shortly, I fully agree with what has been said by the two precedent participants. I think that one of the big issues for competition agencies today is to do their work the best they can and to take into account the relevant criteria. And for example, we recently reviewed our general guidelines at the agency last year, and we took into account all the new developments that should be incorporated in those guidelines. And I don't think you will find the concept of zombie firms in those guidelines. And I don't remember that anyone proposed us to incorporate that dimension, which of course is not a proof that it shouldn't be. And I think that already with the relevant criteria that we have a lot on our plates, of course, for the most complex and difficult mergers that we need to spend a lot of time. So maybe one interesting case to study for the academics will be what became of Cofigeo, because we have decided to forbid the merger because we saw all kinds of ills associated with that merger, and the minister decided to approve it. So I don't know if Cofigeo was a zombie firm, but then it might be a case to study to see what were the effects on the market of that particular case.
Isabelle, that's great, and thanks for highlighting your research agenda for young scholars. That also goes into the direction of doing more ex-post assessments and retrospectives on competition policy, which is badly needed, really, to understand what we are doing. And if we are good at what we're doing, or if we are not good at what we're doing. So that's great. One note that springs to mind, I don't want to take too much time, but you know, that ties to what Karl was talking about. So in a way, it's true that the regulatory environment might be the culprit here, but the idea of letting healthy firms acquire zombie firms and transform them is just relying on a market process. So it's pretty uncostly for society at large to do that, and as a fix to a regulatory problem, which is notoriously hard to solve. So I'm just trying to think, you know, conceptually in terms of, you know, the harm here is essentially a harm to shareholders and maybe to some consumers and the market concerned if we got it wrong, but it's a market process. So that's pretty costly compared to, you know, the heavy cost and political challenges going on with trying to fix banking and financial regulation. Okay, so we had a practical question to which I wanted to turn, and I don't want to squeeze it out. And that goes back again to Jorge and Karl. So one of the hard questions in the discussion about these firms is, how do you recognize a zombie? How do you identify a zombie? How practically can you put a firm in the zombie type? And do we have indicators and tests, filters that allow us to do that? Jorge?
Well, we have a few ones, and I think that perhaps, you know, we can refer to the latest study of the European Central Bank quantifying the presence of zombie firms in the European economy, and they look at three criterion. The first is interest debt coverage. Are they able to with their EBITDA to cover their debt, their interest payments? Secondly, you know, what is the profitability as a percentage of sales? And thirdly is, are they investing or are they not investing? You know, what is that they are doing and how active they are in the market, not in terms of, you know, pricing, but in terms of investment. And look, I mean, there are other indicators. You can look at the usual return on capital employed, return on invested capital, return on assets relative to the cost of capital. And, you know, my experience tells me that however you cut it, you're going to be able to identify more or less the same firms.
Thanks a lot. Karl, What's your grid to identify a zombie?
Well, as I said, we have the notion of company in difficulties in the stated rulebook, which is, I think, quite close, and where we have a definition, in fact, which we developed over the last 15 to 20 years. It is, I think, a bit more granular, perhaps, but it also contains the elements which were just outlined. So if I look at the definition as it is repeated in our general block exemption regulation, we have elements like if, for example, half of the capital of the company has disappeared due to accumulated losses, we would consider it in difficulties, or if it is subject to insolvency proceedings or fulfills the conditions for this. Or the third possibility in our rulebook is very close to what was just mentioned. If the interest coverage ratio is below 1, and at the same time the book debt to equity ratio is higher than 7.5, then we would also consider the company in difficulties. So of course, every definition is somehow a balancing act between catching the ones you want to catch and potentially catching too many or too little. So it's not that the definition is necessarily the only or the best one, but this is the one we are using. And overall, I think it is working well, especially for well-established companies. Of course, if you look at startups, we have exceptions because they normally have totally different business cycles and show different figures. So you cannot easily look at the accounts and derive from some ratios whether they are in difficulties or not. So this is how we have been doing it for quite some years, and overall I think it works relatively well without claiming that it's the perfect solution.
Thanks a lot. We are gonna use what you said here and what Jorge said to try to think about company names. It's always hard. I mean, I have this discussion with my twin brother. He's in a different industry, but he looks closely at these types of firms. And I asked him, give me some names of zombies. And he came up with a dozen of names. I'm not sure we can say the names here, but think about it. You know, I think we all have a little idea, and it would be fun to compare lists in private. Okay, so I see we're running out of time, and yeah, I want to give space for the Q&A, but maybe briefly one last question to the panel, and especially to Frédéric and Gönenç. So in any policy adjustments of whatever sort, I mean, I'm not talking about the sort of grand revolution like the sort of DMA type, DSA, AI regulation type of change, but like just technical adjustments to merger policy. There's always a bunch of unintended consequences and that counsel against the policy change. Can we, if we were to be more open-minded about zombie firms in the process of state aid assessment and merger control, sorry, what kind of unintended consequences might we see? Frédéric?
Well, to me, the question is really about efficiency and the disconnect between market power and efficiency in a way. So if you want, well, if the zombie term is controversial, we can talk about efficiency. And to me, there are two categories of market power. You have the good market power, which comes from efficiency, and you have the bad market power, which comes from the legal status or your ability to attract subsidies. And to me, the policy question is that those two categories of market power are treated in the same way. And this is really a question of priority, in my view, whether you should treat companies with market power like I don't know, the digital platforms, which have gained market power thanks to their efficiency, in the same way as companies with market power relying on inefficiency, because I do think that zombie firms or inefficient firms may have some market power that allow them to remain on the market. So to me, there is a real policy question of whether we want to focus the policy enforcement on bad market power or not. And if we do that, that means that we're ready to accept that efficient firms with market powers will become even more powerful, and we would take the risk of monopolization by efficient companies. But the question is whether this is overall the most efficient outcome for consumers or not.
Yeah, I would say that the Achilles heel of trying to accommodate the zombie firms discussion in merger control could be twofold. One, so what we need to be careful about. One, we should always keep in mind that the prime objective of competition law remains the same. Much like when we are discussing sustainability issues, we're not recalibrating the prime objective of competition laws, and sustainability is actually integrating into the time span in which we are trying to find the welfare maximization. Or innovation goals are a part of the dynamic efficiencies and therefore a part of the welfare goals that we pursue. And similarly, the zombie discussion will have to be a function only of the welfare maximization discussion. And to the extent we lose sight of that and start giving carte blanches because there is zombification risks or contagion of zombification, then we will lose our prime objective perspective. And the second risk would be to lose sight of the fact that this is primarily a fiscal and monetary policy problem. I know that Jorge didn't like me saying that, but I insist by putting emphasis on the word primarily. So I'm not saying this is not an issue for merger control, but it is primarily a fiscal and monetary policy problem, which in turn means that regardless of what central banks hope for merger control, we cannot be a conduit through for easy exit. For all we know, central banks would love no exit procedures at all. Do they even care about the merger control procedures anyway? We love central banks as much as they love the competition authorities and watchdogs. So basically, this is a different sphere of policy enforcement, and we should always stick to the principles of that. But it doesn't mean that we should do things as we have been doing them. As Jorge suggests, I completely agree. We should make sure that this zombification discussion is making heavy inroads into how we process the applications by way of going into the counterfactual analysis, the midterm process analysis, easier derogations, and the efficiency defenses.
Gönenç, I like what you say, but at the same time, I feel a bit I want to give you a little bit of pushback, and in a way, the way you close your remarks sort of dissipates the sort of opposition that I had in my mind. But when you say it's primarily a financial and economic problem, it's a bit of an artifact. It's like when you say COVID-19 is just a health problem, it's primarily a health problem. Well, of course, but it becomes an economic problem, a political problem, a technological problem, which all levels of government have to deal with. So we might be, so I understand, it's primarily there that the problem originates, but I think what Jorge was trying to say, and maybe I wrote with Jorge because we are a bit on the same line, so I'm trying to help Jorge here, and I should not because I'm the moderator, so I'll say something very bad about Jorge in a minute, but about his positions, not about Jorge, who was a very nice guy. But what I want to say here is it becomes a problem for markets because zombie firms prevent entry from more efficient firms and innovative activity, entrepreneurship, and the dynamisms that's at the heart of the consumer welfare mandates of competition agencies. So that's sort of. But I in the end of your remark, we are more open-minded to the thinking. So I like this, Isabelle. I see your hand is still raised, and I'm sure you have something to share.
Thank you. I should have annulled this hand. So
but we would really like to hear you.
I think, well, this discussion has been enlightening for me. Maybe I got a better clarity of what this topic was really. And I do think that for me, the big difficulty in looking at the company per se is that in the merger process, what you are looking at is really the effect of the deal and the effect on the market. And of course, there are some elements that are really relevant in terms of how the company works, what is the purpose of the merger. For example, you know, we rely more and more on internal documents to really be sure of what the real objective of the merger is, which is not always aligned with what we are being told. But really this analysis of is the company a zombie based on the level of its debt, and it's for me it's really a completely different scenario. And I think to this day I think we should be reasonable and not ask too much of competition agencies, because we simply do not have the means to tackle all these different criteria. But I'm still open to getting back to that position, of course.
Yeah, and I promise, if I have an opportunity, to ask researchers here to think very carefully about assessing ex post this transaction, which might provide some good insights to revise and adjust our thinking about it. So we have one question in the Q&A. We had one last question for the panel, but if there's agreement, I suggest we don't do it. We take the question from the Q&A because there's a really good one. And I will rephrase it slightly. The question is directed to any panelist. And if the idea is to allow fresh meat in the market and get rid of the rotten meat in the markets, I'm making up some words here. What's the process what kind of process should we follow? And the question is, the question is moving now. Should we kill all the zombies all at once? Like we're gonna sort of bomb them with a nuke and we're gonna sort of let them collapse? Or should we be more discriminating and go on a case-by-case basis? And I think behind this, there's the question of the policy instrument that we're using to do that. So should you use the sort of case-by-case merger type of stuff, or more horizontal approach? But anyone wants to talk about that?
Very, very quickly. That's really what I was trying to say by saying this is primarily a fiscal and monetary policy problem, because even if we wanted to, we don't have the power to have it happen collectively or individually. These cases will go to Isabelle's desk one by one, and she won't be able to create a holistic policy approach toward these. So that's the fiscal and monetary policy nature of things. And it's also fun to observe that at the beginning of the conference, we were discussing if zombie is a very rude word and whether we should fall back on companies in difficulties, and now we're calling them rotten meat. So this conference has gone well.
I am the guilty one on that, and I read fresh meat, so I thought, okay, yeah, rotten meat.
I'm joking.
Jorge, go ahead.
So I think that there are ways in which you can try to solve the problem more systemically. I think that Karl mentioned those before. I also made a reference to them. You can revise banking regulation. I mean, well, first, if interest rates go up, many of these companies will die, much more quickly. And if you engage in a reform of banking regulation, you may kill them. Many of them are going to visit Isabelle one way or another. They will visit Isabelle as being acquired as zombies if there are no reforms in monetary and banking regulation, or they will visit Isabelle as failing firm defense cases if finally they exit the market. Okay, and I think that in both cases, I would think that we should be doing a proper counterfactual analysis, as difficult as it is.
Okay, so Frédéric.
No, I just wanted to say that one important thing is that even when a zombie dies, there are consequences, and consequences in terms of losing the know-how, losing assets on the market. So there are real consequences to zombie dying. So the only solution to keep those assets on the market, to limit the consequences of zombies' death, is mergers, and to ensure that the zombies exit the market, but still you preserve the assets, and you well, in a way, limit the negative consequences of their death.
So thanks, Frédéric, for highlighting that. That's a very important point. And again, I recall an old paper on the market for corporate control, and he was saying essentially bankruptcy and insolvency and rough exit is a very uncivilized process of exits. And should we think of merger policy as a more civilized or maybe just more efficient process where the know-how, all the tacit knowledge that's in the company stays in the market. Okay, now we have 1 or 2 minutes to go. We wanted to do a survey again, and I had a surprise question for the speaker. So let me throw the surprise questions because it's very funny, and then we do the survey. So the surprise question is the following: you are in Bercy, Paris, in the lobbying, in the room just next to the conference room at the NFA conference, and the word comes down the wire that a zombie apocalypse has broken out. What other competition policy community experts do you want to be standing next to in order to have the best shot of living until the next day? All right. Okay, this is a question. We start with Jorge. You know, Jorge, I told you I would be a little bit.
Well, you know, I will look for my wife. You know, she is now in the same camp that Isabelle is on the other side of the pond, but is the best guarantee of survival. So I would look for her.
Thanks, Isabelle.
I would look for my rapporteur general Stanislas Martin, because he used to be in the Navy a few years ago. So maybe he's got some good ideas to help me fight the zombies.
That's pretty good, Karl.
Well, my wife will not be there, so I think, Nicolas, I would try to be close to you, because I'm not sure we would survive long, but it would at least be fun until the end.
Thanks a lot. Gönenç?
I'm trying to think of you know, large and strong competition lawyer. Bill Kovacic comes to mind. You know, someone with some physical presence. So yeah, I'll go with Bill, I guess.
Thank you. And Frédéric?
I would go to Isabelle, of course, and try to convince her that it's time to join forces.
That's very good. All right, you say that the surprise question was very inoffensive, and we can think more about that. But yeah, I'm sure these are great choices. I would actually go to them now. Now I have my proxy for defense. Okay, do we have time for the survey?
We can try to.
Yeah, I'm sorry, we are 1 minute beyond time.
I'll try to be quick. So let's try to ask again the first question. Let me pull up the poll. So the first question was, how worrying is the phenomenon of zombie firms in Europe? So the majority of you, 67%, answered that it was a bit worrying, while 25% thought it was highly worrying. 8% thought that it wasn't at all. So let's see the results now. Okay, so hasn't changed a lot, Nicolas.
Okay, well, it didn't change much, so we didn't lose. We marginally increased the concern.
Well, I think the same amount of participants have answered the two polls, so yeah.
Okay.
Let's go to the second poll. Okay, the question is, should merger policy be adjusted in a way that provides more flexibility to facilitate the exit of zombie firms? So we had mixed answers. So 58% of you answered that merger policy should be adjusted, while 42% of you answered that it shouldn't. And let's see the results. Hasn't changed a lot, but
well, yeah, but there's an even clearer majority for change. I think that's the way to read it. It didn't change much, but there was a majority in favor. But then again, you can discuss the statistical significance of the sample of respondents.
Indeed. Okay, now we'll go to the third poll. And the question was, should we reform the restructuring aid guidelines post-COVID-19?
So we had 81% in favor.
Yeah.
Let's see.
Okay.
Okay, so yeah, this again is like for the first question, there's just a very marginal increase in support to reform of the restructuring aid guidelines.
But I have no clue in which direction they want to change them.
That's right. Exactly.
That's for the next NFA conference when we are in Bercy and when there is a real zombie outbreak, right?
I'm sorry that we didn't have time for the question by Romain Ferlat, which was a very interesting one, but that would be for another conference in terms of the criteria of derogation between the FCA and the Commission.
Yes, exactly. Sorry, Isabelle, I could not pick this up. There was so much already said. But yeah, that was a good question. And I'm sure that Nicolas Cherby and his team would really like to organize events. We'll certainly find an opportunity in this question to offer something to prolong this discussion. Okay, so it's 5:04. I think it's time to close. I want to thank every one of you here, Isabelle, Gönenç, Karl, Jorge, Frédéric, for the very thoughtful comments and very open-minded and constructive discussion we had. I like these exchanges. They're civil and they're nice. So let's keep on the discussion. We all like competition policy. We want to make it better, and let's hope to see each other in Paris next year.
Yeah.
Yes, indeed. Bye-bye. Thank you very much.
Take care then.
Bye-bye.
I'll leave the floor to my events
Bye-bye.
coordinator. She's going to say a few closing remarks. Thank you.
Yeah, so thank you to our speaker for such an interesting discussion. We will send a survey in a couple of minutes to your email address. We invite you to tell us what you thought about this webinar and what we might be able to do better in the future. The conference steering committee will sit down in September. For example, we had comments suggesting new subjects for next year's conference, such as climate change or killer acquisition. We will continue the debates of new frontiers of antitrust tomorrow with the fourth and last webinar focusing on regulation of platform, those one-size-fits-all. We will have the pleasure of welcoming as speakers Inge Bernards from DG Comp, Andreas Mund from the German Competition Authority, Mike Walker from the UK Competition and Market Authority, Professor Giuseppe Colangelo, Eliana Garces from Facebook, and Laurence Barry from Descartes. The panel will be moderated by Frédéric Génie. This is now the end of this webinar. Thank you very much for joining, and thank you to the speakers and partners, Cleary Gottlieb, ELIG Gürkaynak Attorneys at Law, and Compass Lexecon. Please do not hesitate to share with us your thoughts about this webinar, as we are always trying to improve their quality. We are going to leave the link for your certificate of attendance in the chat for the next 2 minutes. Please make sure to get it before quitting this Zoom session. We hope to welcome you again tomorrow. And if the speakers would like to say their goodbyes, you have the floor. Thank you.
Bye-bye all. Thank you very much.
Bye. Take care.
Bye-bye.
Thank you.
Yeah.
Bye.